My name is Jason Sciciano, and I'm president of Levitt First Associates in Tarrytown, New York. I wanted to talk about a topic today that a number of boards of condominiums and co-ops are unaware, and it's a topic that can drastically affect their liability exposure and ultimately their insurance premiums for many years to come if it's not properly addressed. The topic is related to a law in New York State called the New York State Scaffold Law. New York is the only state in the United States of America that has this type of law. And basically the law says that if a worker, for instance for a contractor working at the condo or co-op building, is injured, particularly in a fall from a height like a ladder or a tree or a roof, that the building will be absolutely liable for that contractor's injuries in a court of law under a liability suit. So obviously the law has huge implications and risks for buildings. Many boards are under the assumption, mistakenly, that if the board or the managing agent collects a document called a Certificate of Liability Insurance, and if that document lists in the description box that the building and the managing agent and board are additional insureds on the contractor's general liability policy, the board assumes that they've got protection, and that if one of the contractor's workers is injured, that the board and the building will be protected by the contractor's insurance policy because this thing says they're additional insured. In fact, if you read the words that are highlighted at the very top of this document, they say this certificate is not worth anything. It transfers no rights, no protection to the additional insureds, and it specifically says that if the certificate holder is an additional insured, the policies of the contractor must be endorsed. Well, what does that mean, endorsed? Most contractors' general liability policies have what's called an additional insured endorsement that states that the contractor is allowed to name anyone that the contractor wishes as an additional insured, any entity, any building, any person as an additional insured, as long as the contractor agrees to do that in a written agreement before the work is started and before the accident happens. That's called a blanket additional insured where required by written contract endorsement, such as this. So the thing is, this certificate of insurance is absolutely not a written agreement. A written agreement states the parties and is also signed by the parties to the agreement. So, in order for a board and a building to be an additional insured on a contractor's general liability policy, in addition to the certificate of insurance, you need an agreement. Two pieces of paper working together. The agreement, which your attorney should really write up and review before it's used, needs to state a few things. The contractor's name, the type of work to be done, the client or the building, the location of the building, and usually the managing agent you'll want to name as additionally insured as well, along with the board of directors. The agreement should state that the contractor agrees to indemnify and hold harmless the building, the board, and the managing agent, and that also the contractor agrees to name all of those parties as an additional insured on its general liability policy. The contractor should also maintain workers' compensation, and this agreement requires that as well because a contractor, such as a sole proprietor working without workers' compensation, adds even more risk and liability to the building. So with these terms, the contractor signs the agreement, and then the managing agent can sign the agreement on behalf of the managing agent and the building that he or she represents, and now you have a written agreement. This agreement does not have to be a separate agreement. It can be embedded into the contract for work, along with how much the work's going to cost and what the scope of the work's going to be, or it can be separate. But there needs to be an agreement, as the endorsement states. So now that you know what's required to be an additional insured, you might think, well, that sounds pretty easy. The fact of the matter is most boards rely on their managing agents to collect this type of documentation. And the problem with that is If you have a typical managing agent, and in some cases these numbers are actually understated, but let's say a managing agent manages 40 buildings. Let's say, and this wouldn't be unusual, 25 different contractors service that building, service one building. Plumber, roofer, electrician, brick pointing guy, masonry guy, painter, etc. 25 contractors, and I already explained you need at least 2 documents. Could be, if the additional or if the workers' comp proof is on a separate piece, could be 3 documents. But let's say 2 times 40 buildings times 25 contractors. That's 2,000 documents that that managing agent needs to maintain for the 40 buildings that his firm is, or her firm is agent for. That's a lot of documents. And while a lot of managing agents say that they do this process well, the fact of the matter is it's a very difficult process to do well and completely all of the time, especially if you're getting certificates of insurance for each and every policy year, because the policy renews each and every year, and you should have a certificate of insurance updated to show the current policies in force for each and every contractor. So the point of this discussion is that boards may not be aware of the exposure by not getting these documents in place properly. These are called risk transfer documents. And the risk in not doing this properly, however small it is, it's a risk, and it can be severe, is that if a contractor's employee is injured at a building, falling off of a ladder, for instance, and is unable to work for the rest of his life or her life, he's going to sue. And because of the Scaffold law, which is unique to New York, that worker will win that lawsuit even if he's drunk, even if he's been affected by drugs, even if he forgot all of his safety equipment and broke all of the rules. The building will still be absolutely liable under this law. The only way to protect is either the building's insurance, which if the building's insurance has to pay that claim, premiums are going to go through the roof for the next 5 years. The quality of insurance the building will be able to get will go down, or ideally the contractor's insurance. And the only way you get the contractor's insurance is making sure he has the insurance with the certificate and making sure you're an additional insured through the agreement I discussed.